What's going on, AP Gut People? Video 47 for you. Important civil liberties to know. Just as an FYI, we only have 3 more videos after this, and we are done with the curriculum. Let's start off talking about the Bill of Rights. This was added in 1791 to the Constitution. Primary author was one James Madison, pictured here, and these are the first 10 amendments listing protections from the government. That's what civil liberties are, protections from the government. Now, originally in the Supreme Court case Barron versus Baltimore in 1833, this is important, we'll come back to this. This stated that the Bill of Rights only applied to the national government, not state governments. However, in 1925, the Supreme Court is going to reverse itself in Gitlow versus New York, and they began to apply some parts, the First Amendment, to state governments. So the question is why? Well, something happens between 1833 and 1925, and we'll get to that in video 49, the incorporation doctrine. First Amendment, this guarantees freedom of speech. Congress shall make no law abridging the freedom of speech or of the press. However, as we saw in the Supreme Court case Schenck versus the United States, if there is a clear and present danger, then this can limit free speech. You're not allowed to yell fire in a theater, but you are allowed to yell theater in a fire hall. The Establishment Clause, this states that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise of. And a Supreme Court case dealing with this is Engel versus Vitale in 1962, which stated that school-sponsored prayer is unconstitutional in public schools. So if you go to a public school, you cannot be forced to pray. It doesn't mean you can't pray. You're allowed to pray in public schools. It just means that school-sponsored prayer is unconstitutional. Lemon versus Kurtzman deals with religious schools, and any government aid in the form of money to private religious schools may not promote religion. So that money could be used for textbooks, for example, or to hire teachers. Reynolds versus the United States in 1879. Here is Mr. Reynolds. This says that the government can regulate religious activities that violate the nation's laws. This court case dealt with polygamy. So just because a religion sanctions something does not necessarily mean that one can practice it. All right, continuing with the First Amendment of freedom of the press. Prior restraint, very important term to know. This is when the government attempts to prohibit the press from publishing information. They try to do this before it happens. And in the Supreme Court case, the New York Times versus the United States, this dealt with the Pentagon Papers and essentially the history of the Vietnam War. The Supreme Court ruled that the government could not stop the publication. Prior restraint is very, very difficult for the government to actually enact. Now, public schools, however, they do not have the same leeway. In Hazelwood School District versus Kohlmeyer in 1988, this dealt with a school publication. They have a much lower standard, but the government has a very difficult time in prior restraint. All right, many court cases you need to know for the rights of the accused. Habeas corpus, this is when you are guaranteed a trial if arrested, and Lincoln suspended this during the Civil War, and that's something that only Congress can during times of crisis. Ex post facto means that you can't be punished for doing something when it was legal if it is now illegal. So for example, in New York State, it's illegal to text and drive on your cell phone. If I did that 10 years ago when it was legal to do that, they cannot go back and punish me for doing it 10 years ago. I can get in trouble now when it's illegal, but not 10 years ago when it was legal. Bills of attainder mean that you can't be punished without a trial, so you can't have a sentence without a trial or pleading guilty. Jumping on over to the Fourth Amendment, states that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. Now, an important term here they need to know is the exclusionary rule. And the Supreme Court says that this does not allow into a trial evidence that was seized without a warrant or during an illegal search. So if the police find something without a warrant or probable cause or during an illegal search, that evidence cannot be used in court. Now in Mapp versus Ohio, this extends the exclusionary rule to states. Now the background of the court case, we'll get into this in a future video, but basically they were looking for a bombing suspect who bombed this man's house, Don King. And if you're wondering why is Don King holding a rocket launcher in this picture, well, it's the only one I could find in the public domain, so we'll have to do. So the exclusionary rule after Mapp versus Ohio is now applied to the states. So we see the Fourth Amendment being applied to the states. Jumping on over to the Sixth Amendment, the accused shall enjoy the right to a speedy and public trial to have the assistance of counsel for his defense. So the right to counsel was extended to state crimes as well. So if you couldn't afford counsel, you would be given him. Now, Miranda rights, you've heard this before. You must be made aware of constitutional rights at the time of the arrest. You have the right to be an attorney. No, I mean you have the right to remain silent. Anything you say can and will be used against you in court of law. You have the right to an attorney. These are things that are listed in the Bill of Rights that the police need to make you aware of when you are arrested. Miranda versus Arizona is what established this. Dude Miranda confessed to a crime without knowing his rights, and it was later thrown out on appeal. Now, the right to privacy, this is not mentioned in the Constitution, but it was established in a court case, Griswold versus Connecticut. Now, here is Estelle Griswold, and this court case dealt with birth control. So the Supreme Court is going to overturn a Connecticut law banning contraception. So birth control is now legal. Now, the important thing is that the Supreme Court implied that there is a right to privacy in the Constitution. It doesn't say this, but it is implied. And this will be used in Roe versus Wade from 1973, which legalized abortion. And this is one of the most controversial decisions of the past 44 years. But without Griswold versus Connecticut and the establishment of the right to privacy, Roe v. Wade might not have happened. All right, for test tips, multiple choice, know the Miranda rights, free speech limitations, Shank versus U.S., the rights of the accused. You have to know that you will see court cases on it. For free response, examples of civil liberties, and then corporation doctrine, which we will get to in video number 49. Thank you guys for watching. Look forward to seeing you back here for video 48, important civil rights to know. Thank you for watching. Best of luck on all of your exams, and have a good day.